Hi, and welcome again, Disability Law Show. Good to have you here for the 30 minutes. Hope you stick around for the entire thing. There's lots to be learned. James Fireman, partner, Samfiru, Tumarkin, LLP, the most positively reviewed disability law firm in the land. John Scholes here as well. Good to have you along. As mentioned, lots to get through in the show today. We'll get to some emails. We'll get to mydisabilityquestions.com. That's another resource we'll talk about. And the 3 key advantages of getting help from an LTD lawyer. We narrowed it down to 3. There's a whole lot more, but we're going to cover 3 big ones on the show today. Reaching out anytime to James and his team, 1-855-821-5900, help at disabilityrights.ca. Real simple, right? But we always start off, brother, with the week that was, something that's you've been working on for the last week or so. What do you got?
Well, I always like to use this time, as you know, to break down misconceptions that people have.
Sure.
And so one of the things that I hear quite frequently from people who are calling me with a potential claim is a concern about, okay, well, what happens if we start this legal process, we challenge the denial or cutting off of benefits through the legal field, and the person gets better? And they're concerned, what happens? You know, if I want to go back to work and we start this process, can we stop it, or am I able to go back to work? Is this going to get in the way? And the very simple answer is, at any point in time, if you are able to go back to work, you should go back to work. And whether you have started a legal claim or not, you absolutely can do that. So let me back it up a little bit and explain exactly what I mean. If, let's say, someone contacts me and we have a mediation booked for several months down the road, and all of a sudden, after starting the claim, their symptoms start getting better. And by the way, that is not uncommon. It happens quite frequently, especially with people who have mental health issues, and especially anxiety and depression, which can be exacerbated by having to deal with an insurance company that's hounding them for information. All of a sudden, we start this process, and they don't have to deal with the insurance company at all, and it's not uncommon that people's symptoms start to improve. I'm not telling you that the solution for, anxiety and depression is starting a lawsuit, but I am saying it is a byproduct that happens not infrequently. Whatever the situation is, though, whether it's because you don't have to deal with the insurer or your doctor finds a new treatment or medication that's going to work for you better, and your situation improves to the point that you feel confident that you could go back to work and your doctor approves, even if we have this mediation scheduled, you can go back to work, and it happens all the time. So let me give you an example. A client that I signed up this year in May, we started the claim, and in August, I believe it was August, they started feeling better, went to their doctor and said, listen, I'm feeling better, I'd like to go back to work. The doctor said, okay, gave them a gradual return to work plan, which they abided by. I said to my client, listen, I don't want to say anything to the insurer yet. I want to make sure that you're going to be successful. So we waited 4 or 5 weeks until they felt like they were okay with it. They were back to virtually full-time hours, weren't having any issues. So I called up my client's insurer and I said, listen, my client has gone back to work. He's been back for 5 weeks now, is feeling good. So I think we can resolve this claim. And it was a matter of, I think, 2 phone calls and an email, and we were able to get to a resolution without even having to go to the mediation. Wow. So yeah, the claim was resolved for less than we would have thought at the outset, because at the outset we were looking for long-term disability benefits, not just that they were owed up to the date of resolution, but into the future, because at that point in time we didn't know when my client was going to be able to return to work. But obviously, as the case went along and my client got better, it became clear that this wasn't going to be something that was disabling them several years down the road. And so the resolution was a more modest settlement than I would have expected at the outset. But so what? That's fine. My client is back at work, earning 100% of their income, as opposed to trying to hound an insurance company for 2/3 of their income, of which they have to pay legal fees out of. It is obviously much better if you're able to go back to work and earn an income. And so starting the legal process does not in any way prevent you from doing that. It just makes sure that if you're not able to return to work, you're going to be in the best position possible.
And that 5 weeks is a short enough time. What I'm trying to say is nothing really happened with the insurance company within that 5 weeks and say, oh, okay, they're already on it. We got to get you back to work. Like, you got a comfortable window there, right? These things take time with the insurance companies?
Yeah, it's not a matter of hiding it from the insurer. Certainly, whether or not my client was successful in returning to work, I would have told the insurer that they had attempted anyway.
Right.
That's information that they're absolutely entitled to. It wasn't a matter of trying to, in any way deceive the insurer. It's really just a matter of approaching the insurer with information that I'm comfortable is going to be complete. Alternatively, I well could have said to them, my client is going to attempt to return to work now and we'll let you know how it goes. I just prefer a simpler approach, but it really doesn't matter one way or the other because the insurer wasn't paying benefits anymore.
I gotcha.
Right.
And that you mentioned that 2/3 income as opposed to getting your full work pay if you're back at work. That's the general level that you're looking at if you're on benefit.
Yeah,
because a lot of people are going to think they get 100%, which is not true.
Yeah, so short-term disability is often at a slightly higher amount. It can be 80, 90, sometimes even 100%.
Right.
But once you're getting long-term disability, the standard long-term disability policies that we see with most group insurance plans is going to pay somewhere around 2/3. Some of them are lower. I've seen as low as 50%. Some of them are as much as 75%. But usually you're looking 60, 65, 2/3, somewhere in that range.
Again, reaching out to James anytime. Questions that arise during the show, no problem. 1-855-821-5900. And another website you can go to, pocketemploymentlawyer.ca. I know it's got the employment thing in there, but it's for both employment and disability law because there's lots of crossover between the two. I know that James works across the hall from the employment lawyers at the firm, and they go back and forth all the time. There's plenty of crossover. And because of that reason, pocketemploymentlawyer.ca, there's a nice section on disability law there as well. If you have questions, you can use that anytime. It's free and also anonymous. But I want to get on to our first email of the day. Again, help@disabilityrights.ca. This one, James, comes from Tony, writes in, says, I turned to long-term disability benefits for support while I battle leukemia. My claim was denied despite the reams of medical documentation I gave the insurance company. I have appealed the denial, but I'm extremely worried as my income has been non-existent for the past 18 weeks and the stress and bills are beginning to mount. What if they still say no?
Tony, I'm going to let you know right now it's very likely that they're going to say no. Yeah. That's what we see with virtually all appeals. Now, what I will say is, it sounds as though if you're suffering from leukemia and if you're getting actively treated for that, I can't really imagine a scenario where you aren't going to actually be entitled to your benefits regardless of what the insurer says. So I would hope in your situation that just the gravity of that diagnosis and the treatment that's required for that type of diagnosis would be enough to compel the insurer to really take a hard look at it on appeal. I would hope that would be the case. But I'm not at all confident that it is. It's just not the way that it works. When you appeal a denial of your long-term disability benefits, all you're doing is you're asking the same person at the same company to take another look at the same information that they already have and somehow reach a different conclusion. And now keep in mind that you're asking them to reach a conclusion that they are explicitly incentivized not to reach. The insurance company, they are a corporation with shareholders. They're in business to make money. This is not a secret. The way they make money is by paying out fewer benefits. And so if they have found a justification to deny your benefits, even if it's really weak, if they have found a justification that they are already prepared to rely on, you're not likely going to change their mind, especially not unless you provide them with very different information. And the reality is if they already know that you have leukemia and you're getting treated for leukemia, what is it you're going to be able to tell them that's going to wake them up? I really don't know what that would be. If you didn't have that diagnosis when you first applied, and then you told them about the diagnosis, that probably would actually be an effective way to appeal. But if they're already aware of it, I'm not really sure what you're hoping that they're going to do with the same information. They're almost certainly going to deny. If they don't, I really hope that they don't in this case, but if they deny the appeal, which I expect that they will, then you give us a call and we start a legal claim. The sooner we start it, the sooner we're going to be able to get to a resolution. And the reality is you're going to get in a situation where they're going to be paying you several years of benefits into the future, and you're not going to have to deal with them on an ongoing basis.
It just seems weird that something like leukemia, as you said, is a pretty severe diagnosis. Tony's getting treatment for it. He's still sick. Nothing has changed, as opposed to, them cutting you off, asking you to appeal if you got a busted shoulder. Do they even bother looking at what you have, or you just go into the appeal mill at a certain time? Send them all in.
I want to be really careful about this because, we're talking about leukemia as a binary situation, either you have it or you don't, but where you are in your diagnosis and your treatment can vary widely, and how that is impacting you can vary widely as well too. And so in theory, I can imagine someone being diagnosed with leukemia, even being actively treated for it and still technically being able to work. It's a real tough argument for the insurer to make, though.
Okay.
Someone who's got leukemia. You know, I say that a diagnosis doesn't matter in the sense that even if you don't have a diagnosis, you can absolutely be entitled to disability benefits. But having a diagnosis, especially one like leukemia, certainly does help in crystallizing exactly the severity of the disability that you're suffering from, and should make it so that the insurer is aware of their exposure to having to pay benefits. It should. Unfortunately, as in Tony's case, it doesn't always happen that way.
Yeah, it's funny when you say it doesn't necessarily have a diagnosis. That will shock a lot of people, but you got to think about mental disabilities. They don't show up in an X-ray so much, right?
Sure, and a lot of people haven't gotten the treatment that they need for that, and so oftentimes what we see is people have a combination of different disabilities that are preventing them from working, physical and mental health, and oftentimes it's the mental health diagnosis and assessment that is lagging behind, and that can often happen later.
Okay, guys, short break. As mentioned after the break, 3 key advantages of getting help from an LTD lawyer. That is on the way, so stick around for that. In the meantime, 1-855-821-5900 to reach out to James and his team, and help at disabilityrights.ca as well. We'll continue on the Disability Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Disability Law Show. Thank you so much for sticking through the break, and we are back at it. As we mentioned before the break, James, 3 key advantages of getting help from an LTD lawyer. All these start with we, but I'm going to say you because you're the lawyer in the room. So there you go. You communicate directly with the insurance company so you don't have to. How big a relief is that? Which you talked about in the first segment, right?
Sure. And so let's talk about the process as soon as we take over a file. So we have someone call us for information to see if it's something that we would help them with. And so assuming that in that first conversation we realize that there's a valid claim there, it's something that we can pursue. The very first thing that we do after the retainer is signed is we immediately write to that person's insurance company for 2 purposes. One is to get the entire insurance file. I'm going to talk about that in a moment. But the second reason, which is applicable to this particular point, is that we let the insurance company know that we've been retained. And at that point, from that moment onwards, the insurance company is no longer able to contact you directly. It's something that they're not entitled to do anymore. And that is a huge relief to so many people that call asking for help, especially those that are suffering from mental health issues, especially depression and anxiety, because they've been dealing with this insurance claim with an insurance company that has already denied their claim or is about to deny their claim and has been hounding them for more information, and often that is going to exacerbate their condition. It's going to make their depression worse, it's going to make their anxiety worse, and now all of a sudden they don't have to deal with that insurance company anymore. They don't have to worry every time the phone rings that it's going to be that claims handler on the other end telling them that they have to do this or they need this information or it doesn't look good or whatever. Getting rid of that communication, getting rid of that pressure from the insurance company on an ongoing basis, even just the threat of that pressure, the threat of that communication on an ongoing basis is a huge relief to so many people. And it's something we talk about. After that is removed, it's not uncommon that people's symptoms, especially their mental health issues, start to get a little bit better. Again, it's not a panacea. It is not the prescription for all that ails you, but it is part of what is a problem for a lot of people, and we can help with that part of it.
I can picture that being maybe not as big as a monetary settlement at the end of the dealing with the insurance company, but I can see that being as almost a bigger relief for people. Just that phone stops ringing.
Yep.
Stop getting emails.
Yeah, it is very common for people who are calling me for the first time when they find out that they're not going to have to deal with the insurance company anymore to openly express relief about that. And they'll say, James, you have no idea how much that means to me to not have to deal with them anymore. And it always amazes me every time. It shouldn't anymore, but it is something that I take for granted because, you know, for me, I'm the one who's dealing with them all the time, and I'm fine with that. It's my job. But for them, it is something that is causing them so much stress and anxiety. And to be able to get rid of that is a huge relief for so many people.
Advantage number 2 of working with a disability lawyer like James is this. You gain access, as you mentioned, to all the information your insurer has gathered in your file. Why
Sure.
can't I do that?
Well, you can try.
Okay.
And there are some situations where the insurance company, usually after several attempts, will actually provide you with that file. More often than not, though, they'll give you the runaround and they won't give it to you. As soon as we ask for the file, they have to give it to us. They're required to, and they know that. And if there's a lawyer writing to them, they know they can't mess around with it anymore. And so we're going to get that whole file. Now, the reason we get that insurance file is, I'm typically at that point not especially concerned about proving the medical case, about proving that my client is totally disabled. Usually I'm pretty confident by that point that they are totally disabled under the policy based on what their doctors are saying. That's who I'm concerned about. This totally disabled thing, by the way, just to go off on a little tangent,
Right.
is, this is something that the insurance companies have invented, this term totally disabled.
It's a good one.
Yeah, it is. It makes them a lot of money. It makes people think that, in order to be entitled to benefits, that you can't get out of bed, that you can't, you can't make your own dinner, you can't feed your goldfish.
Yeah.
I mean, like, that's what it conjures up to you. People are thinking like, in order to get this, I have to be completely incapacitated. Not the case. Mm-hmm. In order to be deemed totally disabled, all you need is something from your doctor that is saying that you are not able to do the regular tasks of your normal occupation. That's all it talks about. If you look in your policy, that's all that's there. So when I look at this insurance file, I'm not looking to prove that you're medically disabled. I already got that. The reason I'm looking through this insurance file is I'm trying to figure out how the insurance company messed up. That is what I'm looking at, because I know that your treating doctors have already said that you're disabled. And if your treating doctors are saying you're disabled, then you are. It's as simple as that. If your treating doctors are telling me that you're disabled from work, the insurance company has made a mistake. So I'm going through that insurance file page by page, and I'm figuring out what corners did they cut? What information did they not properly give weight to? What were they ignoring? Because they obviously have. They got to the wrong conclusion. And my job is to figure out how. And then to make sure at the end of the day that they know that I know what they've done. And when they realize that, they know they have exposure not only to paying your benefits, but to paying potentially punitive damages that can go well beyond the money that they owe just for your monthly benefits.
Plus, I can imagine which one of your clients would actually want to get. I mean, how big is an average file? This big? This big? This big? I mean, your person's sick. They're going, okay, let's have a look at this. I don't know how to decipher it.
Sure.
I can't get through it.
A small file is 300-400 pages, but
No.
I've certainly had files that are in the thousands, and that's just the insurance file.
Not interested.
That's not even including the medical file.
No, not interested at all. Third advantage is this one. You know how and where to apply legal pressure to get results and compensation. That's really what it all boils down to, right?
Yeah, and that's really what I was talking about.
Yeah.
I sort of got ahead of myself in answering the last question, but really what we're looking to do is to find what the insurance company has done and to use that against them. I don't go into a mediation and spend my time trying to convince the insurance company that my client is disabled. When I go into a mediation, that's a given. I'm saying that right off the bat. I'm not here to argue about whether or not my client is disabled and is entitled to benefits. They are, and we know that, so let's not waste our time. What we're here today to talk about is how long into the future are they going to be entitled to benefits, and what is your exposure to punitive damages? What is the likelihood that if this case ever got anywhere close to trial, that you would have to pay more than just what you owe in benefits for the way that you adjudicated the claim, your failure to act in good faith? That is the focus of everything that I say at the mediation. I'm not worried at that point about proving my client's totally disabled. They are.
Already got that part done.
Exactly.
Yeah, already there. There you are. There's 3, but there's lots more. But that hasn't got you convinced. Have a chat with James. Phone him, call him, get more information. No problem. 1-855-821-5900 is the way to that. We'll go to a break, and I'll give you some more resources here as well. Help at disabilityrights.ca and mydisabilityquestions.com. Again, free and anonymous. Use all of it and reach out for sure. We'll continue. More Disability Law Show is on the way.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back, Disability Law Show. Good to have you along. The number to reach out to James and just have a chat. No pressure. 1-855-821-5900. Help at disabilityrights.ca. And another website for you want to check out. You have questions, frequently asked questions, LTDFAQ.ca. LTDFAQ.ca. Again, free and anonymous. Have a look at that. And then finally, help at disabilityrights.ca is the email. I'm going to go back to mydisabilityquestions.com here for a moment. James, this one from Ahmed. Ahmed says, I've been suffering from migraines and nerve pain for almost a year. Because my ability to focus on my work and keep a steady hand was being affected, my doctor told me to take time off work. I applied for LTD, but was told my claim was not sent in a timely manner and that the medical information was incomplete. Is there anything I can do?
So let's talk about exactly what's going on here, because there are 2 different deadlines that can apply throughout the entire disability process, and they are very different, and how they are treated and how they are remedied is very different. The one that we talk about most frequently is the limitation period for bringing a legal claim, for starting the legal process. That's a 2-year limitation. That starts from the day you get notification that your claim has been denied or that your benefits are being cut off if they were being paid before. That is a very hard 2-year deadline, and if you miss that, there's really virtually no way around that. Right. So don't miss that. The other deadline that we talk about on occasion is the application deadline, which is what Ahmed is writing about. Now, oftentimes, if you look at your disability policy, it's going to tell you that you have 30 days or 60 days or whatever it is after you become disabled from work to apply for the disability benefits, to provide your long-term disability insurer with the application forms and the supporting documents that you would need in order to make that claim. If you miss that deadline, oftentimes the insurer will say, well, we're sorry you missed the deadline, you're too late, you can't apply anymore. But that's not really so. Unlike the 2-year limitation for bringing a legal claim, if you miss the deadline for applying, it is very common, in fact, it is more likely than not, that you're going to be entitled to actually have that application accepted by the insurer. There is a legal principle called relief from forfeiture. And essentially what it means is if the insurance company is not going to be prejudiced by the delay, and if you didn't intentionally do it to try and gain some advantage, in virtually every situation, if it ever got that far, a court would say that you're actually entitled to do it anyway because there really isn't any particular reason the insurer can't still process the application. That doesn't mean that they're going to accept the application and say that your benefits are approved, but it does mean that if you're a little bit late in applying, your insurance company can and absolutely should accept your application late or not and adjudicate it the way they normally would. And so that is, the first recourse here. And so in Ahmed's case, I would absolutely encourage him to write back to his insurer and say, I understand that even though I'm late, I'm entitled to relief from forfeiture for the late application. And so if you're not going to process my application, then I'm going to have to contact a lawyer. That isn't something that you need to hire me to do. That is absolutely.
Right.
That is absolutely something that you should be able to do on yourself, because when you see that phrase, relief from forfeiture, most insurance companies are going to understand that
Talk to someone.
Right, that you've talked to someone, or at least are watching a show that's giving you some good information.
That's right.
But in any case, they know that you at least have a better understanding of what your rights are.
Right.
If they were to still reject your application for being late after you do that, we would absolutely just start a claim at that point, no problem. But I really think it's something where they ought to be adjudicating it. As for the second part of this, that the information is complete, or incomplete, I should say, or what Ahmad's insurer has told him, that may well be the case. That may be something where they only have certain parts of his records and need other parts. And so to remedy that, it's important that Ahmad write to his insurance adjuster at his disability insurance, say, I understand that in addition to saying that I have a late application, that you're taking the position that the information is complete. What information are you saying you don't have and require?
Right.
And get a specific itemized list of what they want, and make sure that they get that. Make sure that you have sent that information to them, or at least have provided authorizations for those doctors to directly provide it to the insurance company.
I think we got time for an email. It'll be Caroline. Caroline's up this time. help@disabilityrights.ca. Caroline says, my insurance company conducted a transferable skills analysis. After this analysis, I was told my benefits would end. I have a severe lung condition, and my doctors have advised me I am not ready for a return to work yet. Do I have to accept the insurer's decision to cut off my payments?
No, absolutely not, Caroline. So let's take a step back, as we like to do, and talk about what's going on here. So a transferable skills analysis is typically something that we see when someone is approaching the two-year period of their benefits. Once they've had their benefits for 2 years or sometimes beyond, the insurance company will do this transferable skills analysis, which will, in theory, provide them with a list of jobs that you are able to do, even if they're not what you had been doing before. And the reason for that is simple. After 2 years, the definition of totally disabled under your policy is going to change. In the first 2 years, the test is whether you are disabled from your own occupation.
Yes.
After 2 years is whether you're disabled from any occupation that you're qualified for by training, education, or experience. And so the transferable skills analysis is basically going to look at your entire education, your work history, and your training, and see whether or not any jobs are available to you. But they have to also incorporate your medical limitations and restrictions. And so if they spit out jobs that are clearly not medically suitable for you, if you have a severe back condition and they're saying that you should be doing heavy physical labor, obviously, even though you may be qualified for that,
right,
you're not medically capable of it. So those are two things that the transferable skills analysis has to account for: your education, training, and experience, as well as your medical limitations. But there's a third thing, too. The third thing that it has to account for is the commensurate earnings. And so the jobs that the transferable skills analysis are suggesting you're able to do must pay you a commensurate earning to what you had been making before, which the courts typically hold as being somewhere between 60 and 65%. And so, to put that in more simple terms, if your insurance company wants to justify terminating your benefits, they have to show that there is a job out there that you're medically capable of, that you're qualified for, and that will pay you 60 to 65% of what you had been earning. And I can tell you, having gone through thousands of transferable skills analysis in my career, it is very much the exception that there is a transferable skills analysis that actually properly accounts for all three parts of that test. Far more often than not, they will really overlook the medical limitations, or they will overlook the commensurate earnings, and they'll just spit out some jobs that don't actually apply to your situation. So to answer your question, Caroline, no, you absolutely don't need to simply accept what they are saying, even though they have what might look like a very official report. It is something that far more often than not, after I spend a few minutes on, I'm going to be able to refute pretty easily.
And that commensurate income just happens to be approximately what you were making on LTD in the first place.
More often than not, it's right about that level.
Yeah.
Yeah.
And that is just about it. As we wrap it up, here's how you get a hold of James. 1-855-821-5900. help@disabilityrights.ca is the email address. And I directed you as well to mydisabilityquestions.com. Free, anonymous. Ask your questions there. They will get answered swiftly. And we'll catch you next time on the Disability Law Show.